Hello, everyone, and welcome back to the Robertson and Easterling podcast. I'm Craig Robertson, and with me is my friend, coworker, and partner in podcasting, Matt Easterling. Today's episode is going to be insightful because we're going to tackle a subject that is going to be essential for our clients and super interesting for everyone else, and that is navigating your divorce trial. From laying the groundwork in discovery to making on-the-spot decisions at the courthouse, we're going to share our experience and insight.
Yeah, considering all that's at stake, flying blind into a divorce trial is a terrible idea. You'll want to be as mentally and emotionally prepared as possible. So take a peek with us behind the divorce trial curtain so we can help you put your best foot forward when it's your turn to climb the courthouse steps.
So everybody lean in and listen as we explore how to effectively navigate a divorce trial after this short break for some pre-recorded content.
At Robertson and Easterling, we care about your mind, body, and spirit. Family conflict is emotional and complicated, and it's easy to internalize your problems and not seek help when the battle is being waged in your heart. Whether you think about it or not, life has a certain rhythm. It's seasonal. Some seasons are good, and some seasons are bad. Divorce is only a season. Your life might feel unmanageable, but balance will return. You might feel unlovable, but love will return too. Your children are tougher than you think, and if you love them well, they'll love you back. It's in their design. Your prognosis is good. This season will end. Just like a forest decimated by fire, new life will spring forward. The heat of divorce will change you for the better, and there is greatness within you, only discoverable through what you are facing. Are you in the fight of your life? Don't take chances with your future. We can help.
Well, guys, welcome back, Matt. Today we are talking about something that I think that the average listener might think is super glamorous, and that is going to trial and what that looks like.
Yeah, I know growing up, one of the reasons I wanted to become a lawyer is because I would see trials on TV, and I had this, very, sexy or glamorous idea of what it would be like to be on my feet in a courtroom.
Yeah. And it's fantastic. We're both competitors. We're competitive people. And a courtroom setting it's a competition. There are rules of engagement, and it can be very intimidating for our clients. But quite frankly, Matt, a divorce trial is something that if you can, you want to avoid.
Right. Of course. Like I said, while I was enjoyed or maybe fantasized about those big, days in court, it is somebody's life.
Absolutely.
And if you find yourself in a courtroom for a divorce trial, something has gone horribly wrong along the way.
Yeah, I agree completely. And again, there are parts of trying cases that I enjoy, but I've been doing this now for 25 years, and I've gotten to scratch that itch. And the honest truth is that if you can avoid a trial, that really is the best situation for you. But sometimes you can't avoid a trial.
Right. Sometimes it is unavoidable, whether that be because both sides are just too far apart, or maybe you are unfortunately on the opposite side of somebody who has just lost all reason, or maybe even never had it. Unfortunately, sometimes it could have a big effect who your spouse hires.
And that's a big deal because, we did a whole episode on how to choose the right attorney if you are faced with a divorce in Mississippi. And I encourage our listeners to go back and check that out. But that's right. There are certain things we can't control. And of course, who the judge is, what the judge's calendar is like, the activities of your soon-to-be ex-spouse, and then, of course, the lawyer that they employ and the advice that they give. Those are all things that we can't control that will impact whether or not a case ends up going to trial.
Sure. Sometimes when I look at an initial consultation form and see that a potential client's spouse has hired X, I know that the odds of this thing going to a trial just quadruple.
Yeah, and also it kind of depends on where you live. So there are certain parts of the state where you've got really, really good judges who, quite frankly, make it easier for the lawyers to just try the case as opposed to doing the hard work of negotiation and creating a custom result. So sometimes that geographically dependent too, because certain areas of the state, they're more likely to take cases to trial than other areas of the state. But wouldn't you agree with me, Matt, that generally speaking, that if the parties to the dispute, specifically a divorce in Mississippi, can work out things between themselves with their lawyers, they're going to have a better result than in the event they go to trial?
No question. I tell people all the time, when you have a trial, you are asking the person in the room that knows the least about the circumstances to make a decision.
Yeah, he's a stranger. I mean, he is going to hear, sometimes a few hours of testimony, and in bigger cases could be days or weeks of testimony to make a decision about circumstances that have developed over decades sometimes. And it's next to impossible for it doesn't matter how good of a communicator or storyteller we are as attorneys to put that information in a way that one human being can understand it all and make a fair decision for everybody. I like to say that, when lawyers are making decisions and helping guide people through getting settlements, getting results, it's like we're working with a scalpel, but judges are using hatchets and chainsaws to come up with the same result. They just they have less tools available to them than the practitioners will have in the event you can have healthy dialogue, moving your situation toward a resolution.
Right. And of course, none of that is an attack on the bench in any way. It has got to be an impossibly difficult job. And I can't imagine having to do it. You don't know anything about the facts. You have two sides that are trying to tell a different version of the same story usually. And on top of that, you have people that are actively trying to object and stop the other side from telling their story.
Right.
And that makes everything, incredibly convoluted or murky.
And I think if the chancellor was sitting here with us listening to this, they would agree. It's a very, very difficult job. And we've got some fantastic judges on the bench who really are public servants who want to help people move past the dispute that they have. But like any other human being, we have some really fantastic judges, and we have some that aren't as good, aren't as thorough, and quite frankly, that's one of the things that we have zero control over. So it's not something that we give a lot of thought to on the front end. But certainly, you have to factor in who the judge is and the personality of that judge when you're thinking about whether or not you want to take your case to trial.
Right.
And again, judges are elected in Mississippi, so we have trials in Mississippi before a chancellor, and depending on the county, there could be 1, 2, 3, sometimes 4 of these people, and they randomly get assigned your case, and the person who has been appointed to hear your case is going to have a very, very big impact on how we try to create custom settlements, and also in the unfortunate event that you end up taking your case to trial.
Right. They're going to have a big effect not only on the result, the decision, but the way that they run their courtroom is going to have a big effect on how long the entire process takes.
Sure. And that's not even to mention the expense associated with going to trial, because for every day in trial, it really takes about 2 or 3 days to properly prepare for trial. So if you've got a 3-day trial scheduled, it's going to take us on our best day, probably, 4, 5, 6 days to get ready for that trial. And so you're not thinking about the expense of, 3 days of trial. And a trial day is not a 7.5 hour day. I mean, usually for us, trial days could start as early as 5 a.m. or earlier and go all the way up to 10, 11, 12 o'clock at night, because it really is, when a trial's happening, it's really all that we have capacity to do because it's so intense.
Right. I would, I've never actually done the math and averaged it, but my guess is that in an average divorce trial, a day in court, I usually bill about 15 hours.
Right.
That's getting ready before the trial, in the morning of. That's traveling there usually if it's somewhere local. All of the, events that happen as you're at the courthouse, usually debriefing a client after the day's testimony has finished. And if it's a multi-day trial, you're going back to the office and getting ready for the next day.
Right.
So it's a long day. It's a long process in the lead up to it. And, bottom line, avoid it if you can. But In the event that it can't be avoided, make sure that you have hired somebody that is familiar with courtrooms and that has tried divorce cases before.
Right. And we've got a lot of characters around Mississippi, different lawyers in different parts of the state. And there's a lawyer from over in East Mississippi that I call the professor. And he likes to say that, trying cases is kind of like playing baseball, for attorneys. And some people can just hit and some people can't. And so, there's lawyers who have diverse skill sets, and some lawyers are better on their feet communicating in an open court setting and telling the stories and understanding the rules of engagement, which are the rules of evidence. And other lawyers are better behind the scenes and doing paperwork. And so go back and listen to our episode where we talked about picking the right attorney. And if your case is going to trial, you want to make sure that you have a person who is very, very comfortable in that setting and has a mastery of the rules of evidence, because that's going to be critically important. And again, unfortunately, you may or may not have a lot of control as to whether or not your case goes to trial. But if it does, you want to make sure that you are with someone who being in a courtroom is second nature.
Yeah. And, oddly, it makes me think about that old Teddy Roosevelt quote, which is it walk softly but carry a big stick?
That's right.
Sometimes having a big stick with you actually will keep you out of a divorce trial.
Exactly.
The fact that you have hired somebody that has a reputation in a courtroom, it very well might be what helps settle the case.
Yeah, exactly. And let me tell you, because going to trial, I can tell you, Matt and I we were preparing for a big trial recently before we sat down to record this episode. And it is, even for the lawyers, it is exhausting. It is emotionally, mentally, spiritually exhausting. And I've been fortunate that I've never personally, had my life on display in a courtroom in that way. But I can only imagine how much more exponentially difficult that is for our clients from an emotional standpoint. It's just exhausting.
Right.
And so the bottom line, the first part of this podcast, if you can avoid a trial, you definitely want to avoid a trial. But if you can't,
it's a last resort.
It's a last resort.
Right.
But if you can't, Matt, let's dig in and talk about what it takes to get ready for trial. And really, preparation for a trial starts during the discovery process. Now, if you're new to our podcast, discovery is the formal information gathering process that happens during a divorce. So remember, there are two tracks to divorce in Mississippi. You've got a non-contested track, which is where the parties consent to a divorce. They voluntarily exchange information. They use that information to reach a settlement. That's how most people get a divorce. But also in Mississippi, we have a litigation track. So if you're trying to prove grounds for divorce or there's a contested custody situation, that's litigation like any other type of lawsuit. And so there is a formal information gathering process called discovery. And in discovery, we exchange written questions called interrogatories. We exchange requests for production of documents and information. And then we have subpoena power and we take depositions. And so there are lots of tools for gathering information. So Matt, what would you want our listener to understand about the discovery process as it relates to preparing for trial?
Right. Okay. So first, I would say the discovery process is a long one. Okay.
Yeah.
It's one that's going to start in some form or fashion almost immediately after the complaint for divorce is filed.
And it's ongoing.
And it's ongoing, and it is going to lead you right up to, the days or certainly weeks before trial.
Right.
Okay.
And divorce is change, right? So you have been living a life, maybe 5 years, 10 years, 20 years, 30 years, and then all of a sudden, a divorce throws things in. There might be living in different places. There's different arrangements with regard to the children. And so one thing, it's not like a car wreck or a crime. Those happen in one moment. But the facts in a family law dispute are ongoing and are developing. And, some people, for example, this is a really difficult time. Maybe one of the parents starts medicating with alcohol or drugs or with some kind of a relationship. And so things change.
Right. Well, I always tell people, in divorces, you litigate on sand. Everything is constantly changing beneath you. So going back to the question about discovery, I mean, there's there's all types of discovery, and depending on the facts of your case and maybe how complex certain things are, you might not utilize every single facet of discovery.
Yeah, you want to cast a wide net.
Right.
You want to gather as much possible information as you can because, look, here's the thing. People who try divorce cases, we're storytellers. And so what we're trying to do is gather the raw materials, and that could be testimony from witnesses. It certainly is your story. It could be documents. It could be photographs. It could be videos. It could be audio recordings. It could be cell phone bills. It could be bank statements. It could be appraisals. And Matt, that leads me to think about what's always exhibit number 1 and 2 in any divorce trial is going to be a financial statement. And so if the dispute that you're faced with going to trial over is a financial one of the key pieces of paper is going to be what in Mississippi we call the 805 Financial Declaration. It's named 805 because of the rule, the Uniform Chancery Court Rule 805, that requires us to put together a statement of income, assets, and liabilities. And I cannot stress enough how important it is to continually be tweaking and updating that 805 Financial Declaration as things change and more information becomes available to you.
Right. You can't find a less sexy piece of material that is more important.
It's what every judge is going to look at.
Right. Ideally, if you do your financial declaration correctly, a judge can almost make a ruling off of just looking at that document alone.
Yeah, certainly on the financial aspects of the dispute, for sure.
Right. I mean, involved in it, there's going to be certain biographical information. There's going to be income. There's going to be monthly expenses, assets, liabilities.
Yeah, and that budget,
Okay.
and again, that budget changes. I mean, you might not have been in therapy before, your divorce started, but now you're in therapy. You might not have been taking some kind of medicine for anxiety or depression, but now you are, and that may or may not be covered by insurance, and your therapist may not be covered by insurance, and maybe, a more reasonably priced apartment or rental house is not available, and so that's going to impact the finances. And just like you said earlier, how you're litigating in sand, things are going to change from a financial standpoint, and that's why it's just, I can't stress this enough. It is super important to have great dialogue with your attorneys. You're going to have to, I understand it's expensive, but there's got to be ongoing dialogue, communication, exchange of ideas, updating information. All of that is what the discovery process is all about. And that's why it's trial preparation, because again, most cases, we're not going to go to trial without participating in the formal discovery process. Now, that happens on occasion, but usually it doesn't. And if we don't provide the information during the discovery process, you can't use it at trial. That's why it's important, if we think we're going to need the information, that we have to produce it. And the earlier we produce it, the more likely we'll be able to use it at trial.
Right. I guess this is true of all discovery, but certainly talking about the financial declaration, not only is it important for getting certain facts about your situation in front of the court, there's also things that maybe aren't spelled out on the page that says a lot. Okay.
Absolutely.
When I look at a financial declaration that somebody's provided that is handwritten and every figure in the document is rounded off to a perfect zero, or even to every $500 or something like that, I know that that's something that a person did not put a lot of time, effort, or energy into.
Right. There's a difference between a $300 electricity bill and one that says $259.48.
Right. It also maybe says something about how seriously you're taking this circumstance.
Right.
About how accurate you're trying to be about the information that's contained in it.
Yep.
When I submit a financial declaration to a court, I want the court to be able to look at it and say, I believe that every number on here is supported in some way, shape, or form. And it is tethered, or it is anchored in some type of real number.
Yeah.
This wasn't something where, we licked our finger in the parking lot and filled it out on the hood of the car, which happens.
And that happens. I mean, it's not uncommon. Look, not all lawyers are created equally. Not all people who are in, legal disputes are created equally. And so, sometimes it's the fault of the lawyer, sometimes it's the fault of the client, but it's not uncommon that somebody is in the parking lot trying to scribble out a financial statement and uses that in a courtroom, in a trial. And like I said, it's not ideal. We would never, ever do that, but it happens.
Right. And, even just preparing it will help you get ready.
Exactly.
It helps you learn about, how much do my monthly expenses? What does it really cost for me to live?
It's budgeting.
That's going to help you also tailor what it is that you want or what it is specifically that you're requesting from the court.
And that, Matt, you bring up talking about kind of the story that a financial declaration tells sometimes, outside of the actual numbers that makes me think of photographs too, because photographs are similar. Because if we're going to trial, especially if you're having a custody case or, that's the primary aspect of your dispute, I believe that a picture is worth 1,000 words. And so I'm going to ask you, I want to see a picture of your family. I want to see a picture of you guys together. I want to see a picture of your house. I want to see a picture of, if there's an expensive painting that there's a dispute over, I want to see a photograph of the painting. If you're asking for custody of your child, then I want to see a photograph of that child's room. I mean, so photographs are like that as well, because, there's one document, one thing that tells so much about your life.
Right. Yeah. I mean, I think we referenced it earlier. I mean, trials, a big part of a trial is telling a story. Okay. And the best storytellers are able to do so vividly.
Right.
Okay. So adding things like photographs or sometimes even videos, audio recordings, those can be very helpful to not only tell your own story, but to help the judge put themselves, into your life a little bit.
That's right. I had a client who was just in a horribly abusive relationship, and she was smart enough to, when her husband started raging, to hit the audio record button on her cell phone. And the audio files that she was able to harvest and generate really made the biggest difference in her, not at trial, but being able to use that information to achieve a settlement.
Sure.
And, so you've got to be a little creative. A good lawyer is going to help you think through the type of information that'll help tell your story. But Matt, you said it way better than I could have. It's all about storytelling, and we are making a presentation about your life through the lens of, what it is your objectives are. And so, Matt, that brings up another super important point, and I think we've talked about this before, but it's so, so very important to define your objective if you're in the unfortunate situation where you are headed to a trial.
Right. Well, you've got to make a plan and chart out how you're going to get there.
That's right.
Okay. And so if you don't have an idea of specifically what you want, I mean, how can you really expect a judge to get there?
Exactly.
Okay?
And I wish this was my idea. I stole it from a lawyer who's a little bit older than I am, but we have started to, when we're going to a trial, and guys, trial means lots of things in family law, because we have a preliminary hearing called a temporary hearing, and it's basically a trial. It's a mini trial. Now, it might take only a couple of hours, but when you're going to court in a family law dispute, I think that everything that we're talking about now is applicable. But one of the things that we create is a simple document. It's usually just one page, and if I were representing Matt, it would say what Matt wants. And it just is a bullet pointed list, number 1 through 10, 11, 12, of what it is that our client wants. And if we don't represent you and you're listening to this, that might be something that you want to talk to your lawyer about, is a clear articulation of exactly what you want. And like you said, Matt, if you don't know exactly what that is right now as you're listening to our voices, then that is something that you want to be spending a lot of time thinking about. Sure. Exactly what you want. If you want a joint physical custody arrangement, then you need to be able to articulate exactly what you want that to look like and why you want it to look like that, and why that promotes your child's best interest.
Right. And, we mentioned how the divorce, the discovery process is something that, it really kind of spans the entire life of the case. I think that, having a defined set of goals and what you want or what you're looking to achieve out of a case ought to be like discovery, and that it's something that you should start to create at the beginning, and it should be a living, breathing thing that gets, tailored and more targeted as you go from day one all the way to the day of your trial.
Right. And we've talked about this before. I mean, that's one of the things that I think sets us apart. In the very first meeting, we're going to ask you, what do you want? And of course, that's going to change from the initial consultation to preparing for your trial. But again, there's got to be ongoing dialogue about what it is that you want, what it is that your goals are, what it is that is going to make you as comfortable as possible moving through this this part of your life where it's all about change.
Right. And as the information continues to come in, maybe what you want doesn't actually change, but possibly some of the information that's coming in, it might mean that what you want isn't realistic, or availability.
Well, Matt, you said it better than I can. And a good lawyer is going to tell their client, listen, I understand that you want the beach house in Florida, but it's going to have to be sold. I mean, and so you've got to know what you want, but there's also got to be someone, AKA your lawyer, who's going to keep you in check with regard to that. Like, look, I know you want, his grandma's, antique lamp, but more than likely you're not going to get that. Right. And so, that's part of our job is to tell people hard things sometimes. And so, what do you want? But is that reasonable or not?
Yeah, the available tools to tell this story, it's not going to end up with the result that you want. Or sometimes maybe there's more that can be achieved than what you originally thought.
Yeah.
Again, going back to the fact that it feels like the whole case is happening on sand. I mean, sometimes people's positions improve throughout the case. Sometimes they go the opposite way.
Right. I agree. Like, this is a great example. Maybe there's one of the spouses that has a problem with alcohol, for example, but they get in recovery. And as time goes on and they stay sober and they stay engaged in the recovery process, then their position can greatly improve. I mean, sometimes it is the toxic environment that you live in that home. And sometimes you have to break out of that to get healthier and to get better. And so, yeah, absolutely. Sometimes your situation improves. And sometimes the opposite is true. Sometimes you might be the victim of your spouse's bad behavior, but you start making poor choices or you stumble into a relationship that you never intended to be in. And so, again, things change, and it's important to stay in close contact with your attorney. It's important to resolve as many of the issues as you can. It's super important to do a great job in the formal information gathering process called discovery. Super important to know what you want. But Matt, let's move now to the big day is approaching. And certainly, first of all, how do trials get scheduled? Let's start there.
Well, I mean, a lot of that, again, is dependent on which judge you're in front of. But I would say in most circumstances, it happens through some type of agreed order or a scheduling order where, our office and the attorneys on the other side get in touch with the court administrator. For those that don't know, a court administrator is sort of like the gatekeeper to the judge.
They keep the schedule.
Right. We don't get to talk to the judge typically.
Right.
If I'm setting a trial, I don't call and say, "Oh, hey, Judge Smith, let's do that." Like, that's not how it works.
Right.
You talk to their court administrator, and they hold the keys to everything.
Yeah.
And then you're having to coordinate a day or a number of days that is available before the court that also work for our calendar and counsel opposite's calendar.
Right.
And sometimes that's difficult.
And if there's a lot of lawyers involved, it's going to take longer to get something set. If you live in a busy metropolitan area, a larger metropolitan area, it might take longer to get a trial date scheduled. And they don't always, just because I call and say I want a trial date, they won't always just give you one. Sometimes they want to make sure that you've completed the formal discovery process, the information gathering process. Sometimes they won't. Sometimes they'll set a trial the day you file your complaint. It just really depends on where you are. And that's why it's super important to talk to an attorney, work with an attorney who is very familiar with your local area. And that doesn't necessarily mean they live there, but there's got to be a high level of familiarity with the court administrator, their tendencies, the scheduling, how long you're waiting for a trial. So again, just because we want to set a trial doesn't mean that we're always immediately able to do that.
Right. Some courts will put a defined amount of time that each side has to either put on their case or also cross-examine, witnesses from the other side. So in that instance, if let's say you set a 3-day trial and the judge says, okay, each side's getting a day and a half, or each side is getting 10 hours or something like that. You're on a clock and that thing is going to finish in that 3 days. Some courtrooms are run differently, where once they blow the whistle, the plaintiff starts and they're going to get to dictate the pace of the case a little bit, until they're finished.
Well, Matt, you said that. So just for our listener, the plaintiff is the person who files first. And the advantage in filing first is you get to go first at trial. It's kind of like baseball, that the visiting team bats first. And in baseball, you want to be the home team, you want to bat last. But in a trial setting, if I get to choose, I always want to go first, because you get to set the pace. You get to tell the story first.
Yeah.
And that's important.
You get to draw first blood. I mean, I think there's pros and cons to each. Right. I agree with you. I guess if I had my pick, I would probably prefer to be the plaintiff. I think first impressions matter. You get to get out there first. You're in front of it, and you get to set the pace. However, if you're the defendant, don't worry. These are small differences.
Yeah, everybody is going to have their opportunity to say what they want to say within certain reasonable parameters. But again, you might not get to choose. It's a luxury if you do get to choose. I'm just like Matt. I tell people I'm a fullback. I want to run right at you. So give me the ball. Let's go first. And that's just my mindset. And again, that doesn't mean that if your spouse filed first, that all of a sudden all is lost, because it's not.
Right. I mean, look, if you're the defendant, arguably you're getting the last word.
Okay? You get to hear everything before you have to speak.
Yeah, right. You get to know, from the attorney's perspective, I get to see the story that's been put on first. And so sometimes I know, okay, how many points do I need to score? What type of risks do I need to take here?
Or they've taken their best shot at you, and you don't even have to put on your case because they haven't been able to meet the burden that they have.
If I know they've punched themselves out and there's just nothing left for them to do, I don't have to bring out something that's super risky. I might know exactly what has to be done in order to win that case.
Right.
Sometimes maybe something didn't go your way early on, and I know that I've got to throw a Hail Mary. There is an advantage sometimes to knowing that you're having to throw one, as opposed to if you're going first, you just got to try to score as many points as you possibly can.
Right. And so I think the moral of the story is, guys, that you trial preparation starts before the day before the trial, right? We've talked about all the information gathering process and sometimes the difficulty of actually getting a trial set. But Matt, let's say we've got a trial set that, of course, you've put that day on your calendar because it's a big event. You want to make sure that you take off. If you've got a 3-day trial, you're going to want to take off certainly the 3 days of trial, but you might also want to consider taking off a couple of days before the trial. You also might want to take a day off after the trial for recovery, because it will be one of the most difficult events in your life, honestly. If you have to journey through a divorce trial, it will be just exhausting, exhilarating, emotionally complicated. It's going to challenge you, that's for sure. And you're going to want to be preparing in advance of the big day.
Right.
And so let's talk through, Matt. We've got a trial set. Again, we just settled a case that was set for trial. And so what starts happening is we start digging back into the discovery, the information that has been exchanged. We're going to be wanting to tweak and update your financial statement. And we're going to be wanting to pull out the key pieces of information that we're going to need to be able to tell the story.
Right. And those are the things that are ultimately going to be offered into evidence.
That's right.
And the way I explain it to people is you're going to be telling your story, and then the evidence that we're going to offer before the court. Those are things that are going to support your version of things.
That's right.
Okay. So, I might not need to put into evidence every single financial transaction that, supports my client's story. I might only want to put in the top 3 or 4, that sort of paints a picture for the court as to what we're talking about.
Sure.
If you tried to put in every single one from over the course of a 10-year marriage, you'll be there for weeks.
Right. We have to be mindful that you are given a window of opportunity to tell this story. And like you pointed out earlier, sometimes you're on the clock. And so we have to, you can't always say everything that you want to say, and you can't always use every piece of paper that you want to present to the judge.
Well, and I mean, we talked about, setting the pace if you're the plaintiff. Well, just like in any good story or movie, you want to be mindful of your pacing. Because if you're sitting there and you're just getting bogged down in, hours worth of, minutia and going through these little individual transactions, you're probably losing your audience.
Yeah, and your audience you're an audience of one, right? The judge in a Mississippi family law dispute is your audience, and you've got to present the information to that audience in a way that they can understand it, they can digest it, they can consume it, because you'll be asking them to make super important decisions.
Right. I was taught early on, that you want to make sure as an attorney that you are paying attention to the judge.
Absolutely, yeah, for sure.
In a lot of ways, it's juggling, because you're asking questions, you're listening for the responses, you are listening for objections, and you're also trying to pay attention to the judge. I can usually tell, when a judge is not interested in things that we're talking about anymore, because you'll see it in their body language. They'll put their pen down. They'll push their chair back away from the bench. Sometimes
they'll look at the phone.
Right. Some judges have computers that are up on their up at the bench, and I'll notice that they're paying more attention to something on their screen as opposed to what we're saying.
Right. If they're playing solitaire, we might want to move on to the next thing.
At the same time, sometimes you touch on something and I can see their ears perk up.
Right.
And it's
eyes
like,
get a little bigger, ears twitch.
Right.
What are we talking about now?
They want to hear more about this.
That's right. That's
okay,
true.
so let's talk about this.
Yeah.
So sometimes you got to you definitely want to plan as to what you're going to do, but I also feel like you have to grant yourself certain flexibility to move on from a subject or dive deeper into a subject if it calls for it.
Right. When I was a young lawyer, I would almost script every single question that I had. And again, for all the reasons that you just said, that can be handy to have a script or to have a guide, but you've got to be able to adjust on the fly based on how much time you have, how the story is unfolding, whether the judge is interested in that particular point. Right. And so you want to make a plan, but you've got to be prepared to deviate from that plan. And so again, if we've got a divorce trial, we're going to be in constant communication. We're going to have you in the office. We're going to be practicing your testimony. We're going to be talking to all the witnesses. We're going to be pulling together the discovery. We're going to be updating your financial statements. We're going to see what key pieces of information, photographs, audio recordings, video recordings that we're going to need. Matt, take us to the day of trial from start to finish. Well, even before that, in the days leading up to the trial, what's happening?
Right. So in the days leading up, obviously, most likely your attorney's office is going to be marshaling all of their resources to getting ready for that big event.
Oh, yeah. Ours was, literally just direct because we had demonstrative evidence, blown up documents, and just paper everywhere.
Boxes everywhere, right.
A little organized chaos, really.
Right. As you're leading up to let's say the day before trial, you're getting ready to land the plane. You've made your copies of your exhibits. You've probably got an order in which that you're going to want to try to put them into evidence. You've got an idea of what witnesses you want to call first and what information you're going to try to get from them. I would say certainly for the parties, the night before you need to do your best to get a little bit of rest.
Yes,
you need to make sure that you have eaten something, that you're hydrated, and get as much rest as you possibly can.
Avoid alcohol certainly drugs,
Right.
but anything that's going to disrupt your sleep, disrupt your ability to get yourself mentally, physically, spiritually ready for this event is going to be super important. I can't stress how much, if you don't remember anything else that we say in this podcast, how important it is to practice great sleep hygiene when leading up to a trial, because you're just going to need to be as rested as you possibly can be. And it's going to be really hard to sleep, but being able to sleep and going into this event, because let's face it, you know everything. You know the story that it is that you're going to be trying to tell. And so being rested going into this stressful event is super important.
Right. Yeah. It's their lives. That's what we're talking about. So I tell people we're going to tell the truth, and you want to have as clear of mind as you possibly can. Okay. So, whether you shower the night before or the morning of, whatever, I suggest take a shower.
Shower.
Get dressed. You need to wear something, like you're going to a job interview.
Yeah, and that's a big question we get. Well, what do we wear? Even in our most recent case, we had our clients sending us, hey, should I wear this? Should I wear that? And that's important, Matt. What advice would you give to men or women with regard to what they should wear to the big day, to a trial?
You want to wear something that I think reflects your feelings about the event that you're about to take place in.
Yeah, you want to take it seriously.
Right. I'm not saying you have to show up in a 3-piece suit or a tie, but you want your clothes to be clean. You want to wear closed-toe shoes.
Yeah, if you have facial hair, you want it to be neatly groomed. You want to try to avoid flashy jewelry. You want to, if you're a mama and you're in a contested custody case, I tell my clients, dress like a mama. I mean, and what you'd be wearing to First Baptist Church in Jackson on a Sunday morning is more than likely going to be appropriate. Mississippi is a very conservative state. I have no problem with body art or piercings or tattoos, but again, you want to minimize that. You want to look as conservative as possible and dress for the occasion, because it's a super important occasion. And you don't, like I said, you don't have to wear a suit and a tie, but you certainly want to be neat, professional, and also comfortable, because it certainly is a very uncomfortable endeavor to walk through a divorce trial.
Well, I think most people just assume that the only thing that's important are the things that they say when they're on the witness stand. And while that is incredibly important, what you say while you're on the witness stand, you have to understand that you are being observed and watched basically from the moment that you get inside of that courthouse.
Well, really from the time you step out of your car. And Matt, I'm glad that you brought us. So we're at the day trial. You've pulled up into the parking lot. Certainly every courthouse in Mississippi is a little different. Some are modern, some are more historic. But from the moment you step foot out of your car, there are deputies, there are clerks, court reporters, court staff, court administrators. This is a small community when you're stepping into a courtroom. It'd be like coming into our office. We've got just 6 or 7 people. It's the same way at a courthouse. I mean, the staff is usually going to be relatively small, 4, 5, 6 people, and they're paying attention. Oh, these are the Smiths. They've shown up for their trial today. Whoa, what is she wearing? Whoa, look at that jewelry. What about that tattoo? What's that crazy hat he's wearing? So the minute you step out of your car, you're on trial, and you need to act that way.
Right. You are already telling your story.
Telling your story. I agree.
Be aware, most courthouses in Mississippi, you're not going to be allowed to bring your phone in.
Yeah, that's a great point. You want to leave out, if you wear an Apple Watch, if you have a phone, iPads, computers, you need to be in conversation with your attorney, because each courthouse is different. But generally speaking, Matt, wouldn't you agree? No phones, no Apple Watches, no electronic devices.
And I mean, number one, I'm trying to save you a trip back to your car.
Yeah, no pocket knives, no large guns.
No
small
weapons.
Guns are fine. No guns.
Also, I've seen people get, kind of thrown. Just because they weren't expecting something.
Right, pocket knife or something like that. Something simple.
Right, you pull up and you can't find a place to park. You're struggling, and maybe you're running a little behind, and then you've already got this, enormous event that's getting ready to get started. And sometimes all it takes is just one, little thing to kind of tip over your apple cart.
Ma'am, I'm going to have to get you to take that Apple Watch off and take it back to your car.
Yeah, right. You
can't have your phone. So, think about childcare. I mean, these are the kind of things that you're going to have to plan ahead. Now, you're a parent, and look, you might not be at carpool at 3 p.m. So you've got to plan accordingly for your children, and simple things. Like I said, if you have a pocket knife, leave it at home. Don't wear your Apple Watch. Wear a different kind of watch, or don't wear one at all. And so again, but little things can throw you off. And if if it's already a stressful, chaotic day, and when you're walking through security, all of a sudden they say, ma'am, I'm sorry, you can't have that watch, and you have to take it back to your car. Again, that can throw you off. So you want to think about and prepare for those things ahead of time.
Just minimize the distractions, minimize the things that can, tear away your focus.
Yeah.
Okay.
And so Matt, so we're at the courthouse.
Right.
We the very first thing we're going to do is we're going to walk through security. You've talked about that. You can't have certain electronic devices. It's not as bad as trying to get on an airplane, but you can't have pocket knives. They may or may not allow you to bring in like a drink or water or coffee or something.
You're
like
going to
that.
go through a metal detector. Somebody's going to look through your bag if you have a purse, or if you're carrying a briefcase or something like that. Be prepared for those things. You mentioned earlier about how in a courthouse ecosystem, there's lots of different players that are constantly there. You need to treat everybody with dignity and respect.
Absolutely.
You should do that anyway. Just
but
period.
Especially on the day of your trial.
I can assure you, those people talk to one another. The court, when I say the court, I mean the judge, is aware of how you're behaving, how you're treating people.
Yeah, they're human beings. They talk to each other.
If you decide you're going to dress some, a security guard down because he's told you that you have to take your phone back to your vehicle, and that's just unacceptable to you because you have to be able to look at Instagram, they're going to hear about it.
Right.
Okay. And that is, right or wrong, that can affect or tint the way that the court, views you. Once you get there, we're going to get through the metal detectors. Usually, you and I, we're going to try to get there early enough where we can get you into what we would call a witness room.
Right. And different courthouses, again, are set up differently. Some are super modern and have great accommodations. Some aren't, and some are more difficult to navigate, and some you're going to be with the masses, so to speak. And so, but ideally, we want to try to get you in and get you into a private space if we can.
And actually, something you just said made me think, talking about the dress code, plan for layers, because some courthouses are incredibly warm and hot. Some are frigid.
Right.
And so you want to be comfortable. You need to bring a little, a jacket with you or something that you can easily take on or off.
Good point.
To stay comfortable.
Yeah, I agree.
So once we get you into a witness room, if we can find one, there's usually going to be something called docket call. That's where the judge is going to call out different things that are
roll call. Like
day.
Think back to high school where they're going to call roll. We're going to call the cases. We're going to find out how much time each case is going to take. And sometimes you might be the only thing on the docket, which is the court's official list of cases that it's reviewing for that particular day. Sometimes you might be fifth or sixth down the line, and they could be super short things. It just really depends on where you are and why you're going there. And that's something that we try to check ahead of time, but emergencies come up. You could be scheduled for a 3-day divorce trial, and then on the first morning of the first day of trial, the court has to deal with an emergency that takes up a lot of the time. So, we have to plan, but when we get to the actual event, we have to be prepared to adjust.
Right. Before most trials start, there may be a conference in chambers, and that's where the lawyers for both sides go back into the judge's office.
Yeah, it's where the judge is going to want to hear kind of the coming attractions.
Right.
Like, hey, Matt, why are you here today? What's this case about? What's in dispute? Is this really a custody case? What are we fighting over today?
Right. And, from the attorney's perspective, that's one place to kind of start laying, some groundwork. I mean, I know that I always make sure that I don't say anything in chambers that I am not prepared to prove. And I believe, after doing this for 15 years now, at least the judges that I'm in front of primarily, they know that if I'm saying something in chambers, it's in one of the dozen boxes that I've got, sitting out by my table. So you're going to get to, start telling the story a little bit, there in chambers.
And that depends. It doesn't happen every time, but don't be thrown off if it does. And so ideally, we're going to put you into a private room. Sometimes we have better rapport and dialogue with counsel opposite. Sometimes we don't have any rapport or dialogue with counsel opposite. Sometimes the judge is going to want to talk to everybody ahead of time and kind of hear the elevator speech of the case beforehand. Sometimes they're not. It just really, really depends on who the judge is and where the case is. And unfortunately, the answer to a lot of questions is it just depends. It depends on the day, depends on the judge, depends on the location, depends on the case.
And you're just going to have to trust your attorney to assess that circumstance and draw from it what they can, if there is anything to draw from.
Right.
Okay.
Sometimes there is, sometimes there isn't.
Right.
So Matt, let's go to the big event. Let's go. We're at counsel's table.
All rise.
All rise. We're calling our first witness. Let's back up. Sometimes depending on the courtroom that you're in, there could be a prayer. There could be a pledge of allegiance. Different counties have different things that they do, different traditions that they do before you actually start. It's like the beginning of a ball game. It depends on the ballpark you're in on what the pregame activities are going to be. But judge walks in, everybody stands up.
Right. You'll hear the bailiff call all rise. Everybody stands up. The judge walks in from usually from their chambers or somewhere in the back.
And the chambers is just their office.
Right. And then you're going to get started. You be aware that chancery courtrooms are open, so there could be other people that are in the courtroom listening.
And usually it's people that are there because they have a case there. It's very uncommon, but it's happened where there could be a reporter or somebody who's there just out of pure curiosity. Another common question would be, should I bring anybody who, there to support me to witness the event? And generally speaking, if that person is going to provide support emotionally for you, then that's probably a good idea if they're not going to detract from the situation or distract you from what we're there to do. And also if they're not going to distract the proceeding in any way. But it's good to have some emotional support if they're supportive.
Now, I would say most times the people that you're going to bring to support you might very well be a witness in the case too.
And what does that mean for people?
Well, so if somebody's going to be a witness, there's something called the rule of sequestration. And so you can't sit in there and watch testimony if you're going to testify in those proceedings later.
Yeah, people are familiar with like a jury being sequestered, like in a big criminal trial. The idea is that a potential witness can't sit in the courtroom and listen to the testimony and possibly change or modify their testimony to be consistent with what they're hearing in the open courtroom.
Right. So a lot of times I have people that they will bring a support team, and that team, for the most part, might stay in that witness room where they originally are. And, you'll be able to talk to them during breaks and things of that nature. Once the case starts, whoever the plaintiff is, they're going to say, Mr. Robertson, call your first witness, and then you're off and running.
Yeah, and usually you notice that Matt said, call your first witness. Opening statements don't happen in Chancery Court often. They do on occasion. That's usually what that meeting in chambers is normally about, because argument of an attorney is not evidence, right? And so I have done opening statements in the course of my career, but I would say they're the exception, not the rule.
They're rare. And again, going back to what we said earlier, your story, you're telling your story from the moment that you get out of your vehicle, okay? So that's also when you're sitting there, at counsel's table. I know in our office, we try to talk to clients in preparation to kind of let them know how the courtroom's going to be set up.
Are you going to be facing the judge? Are you going to be to the side of the judge? Each courtroom has different furniture placement. And again, a courtroom is set up for a question and answer exchange. And again, sometimes that might be facing the judge head on. Sometimes you might be to the side of the judge. I think it's important for a person who is going to a family court trial to understand that that judge is their audience. And so they might be receiving questions from the lawyer. It's just not a two-way conversation between witness and attorney. You want to bring the judge into that conversation. So that's one of the things that I tell my clients before we go into court is that, look, that judge is your audience. You don't want to be weird about it. You know, if I'm having a conversation with you, the listener, and Matt, then I'm going to be going back and forth and engaging with my eye contact and my body language, both of those people. And that's exactly what you want to do in a courtroom setting. Like, again, not in a weird way directed toward the judge, but in such a way that they are brought into the communication, even if they're not talking. And some judges will. Some judges want to break in. They want to ask questions. If they don't understand what you said, they might ask you to repeat something. So some judges just let the lawyers do the talking, and some judges are much more engaged, and they will interrupt and they will challenge something that someone says.
Right.
And that's perfectly normal.
Right. Whether you are going to be the first witness and you get up there and you start, your testimony, in the event that that's the case, that is something called direct examination. That's where your attorney will be asking you questions. In those circumstances, your attorney's limited by the types of questions that they can ask you.
Yeah, explain that to our listener, man.
Okay. Well, for the most part, with the exception of, sort of preliminary questions, attorneys are limited in asking friendly witnesses. They have to ask non-leading questions.
Right.
Okay.
Instead of, Matt, did you have a bagel for breakfast this morning? What, if anything, did you have for breakfast this morning? You can't assume the answer in your question. And sometimes we cheat and we do it anyway if you're having a hard time. Again, that's kind of bending the rules. But typically speaking, in a direct examination, you have to ask non-leading questions, meaning questions that do not assume the answer.
Right. Who, where, what, when, why, how, things like that.
Of course, the opposite is true when the other side is asking you questions, and they can ask leading questions. They can assume answers. Matt, you had a bagel for breakfast this morning, didn't you?
Correct.
Right. You stole that bagel this morning, didn't you?
No, I didn't.
Type of thing. That's how you ask those challenging questions that assume the answer. And like I said, not all attorneys are created equally, and some are better at it than others are.
Right. So no matter who is questioning you, whether it's your attorney, whether you're being cross-examined by counsel opposite,
or the judge,
or whether the judge is asking questions, it is crucial that you listen to the questions that are being asked of you
carefully.
Try your best not to think about, how you're doing, trying to gauge how it's going. One of the few things that I have learned is that people are notoriously bad at determining how something is going in a courtroom.
I agree.
Don't focus on that. You have to control the controllables, which is you. Make sure you hear the question. If you didn't hear it, say so.
Right.
I'm sorry, I didn't hear your question.
And a perfectly good answer is, I don't know.
Right.
Or I don't remember. Or I don't understand your question. So in a courtroom, it is critically important for there to be clear communication happening between the person asking the questions and the person answering them. And so if you don't understand a question, you should make sure you clarify the question before you answer it. Those are basic, typical things. Matt, speak a little bit about how we decide what witnesses to call first, because if we're the plaintiff and we're doing a divorce trial, that doesn't necessarily mean we're going to call our client as the first witness. Can you give our listeners some insight into how we decide the batting order, so to speak, the order in which we call witnesses?
Well, Again, it depends.
Right.
It's
maybe
very
we could call the
fact-dependent.
podcast. It depends. It really does. It depends.
Some of what determines that is certain evidence that you need to get in. There might be certain documents that you need to build a foundation for.
Right.
The only way to get them into evidence is going to be if I bring somebody from the bank.
Right. Authentication is the word. It's if my bank statement has my name on it, I can probably authenticate it. But if it's my father's bank statement, I might need my father or a person from the bank to authenticate it, meaning that this person has knowledge of what it is and they can tell the court that it is what it is.
Right. Now, there are certain circumstances, I would say most of the time, you know, we're not going to be forced to bring somebody from the bank to get some bank statements.
Yeah, there are rules that
they're going to be
you can authenticate things
generally
without that,
accepted,
sure.
and so sometimes we don't have to do that, and that's a more efficient use of time. I would say 9 times out of 10, a divorce trial is going to open up with one of the parties.
Right, because let's face it, Matt and listener, most of the information is going to, if it's a divorce trial, it's going to come from you and your spouse. I would say 90% of the information. Other witnesses are providing 10% at best, probably, of the information that the court is going to be making decisions about. Now, that 10% is super important,
right,
because obviously, people can experience the same event and communicate about it totally differently. Matt, you and I are sitting here doing this podcast. We're here at Blue Sky Studio with our friend Casey, and we could go tell our spouses something totally different about the experiences that we had. And that's how storytelling works, because different witnesses will have a different account of the same event. And that certainly happens in a divorce scenario.
At the end of the day, the judge is having to decide who he or she finds to be more credible, okay? Because you're telling different versions of the same story, usually. It's just the way, what lens you're looking at it through.
That's right, yeah.
So that, if 90% is coming from the parties, that extra 10%, which is going to come through, your documents and your photographs and recordings, things like that, and witnesses, those support the story that you're telling.
Yeah, it's called corroboration. So
Right.
you have to corroborate what it is that you're telling. And it could be as simple, I walked into the house and it was a wreck. I snapped a
Right.
picture with my cell phone. Here's a copy of the photograph. The house was a wreck.
Right. So, whether you are, leading off the proceedings or whether you're closing the proceedings and you're the last witness that we've called, no matter what you're doing, again, remember, you're telling your story even when you're not speaking. So if you're on the witness stand and you may absolutely hate your spouse's attorney, okay? They're still an officer of the court. They still deserve your respect, and the courtroom and the proceeding itself deserves your respect. You can vehemently disagree with somebody and still do it in a respectvel manner.
Respectful, kind manner.
No, sir. That is not true. That is not what happened.
Body language is important. I mean, I've got kids who played sports. I was involved in sports, and body language is a big deal.
Sure.
And, all of that is, again, it's not just the words that you're speaking. It's how you look. It's how you conduct yourself.
Yeah.
It is how you engage with the other people that are a part of the court staff, or people that you brought with you, or what you might be doing in a small town at lunch. I mean, again, there's so much that you communicate without opening your mouth, and you've got to be mindful of that if you're going to a trial.
Yeah. Stay present. Pay attention to the questions that are being asked.
Stay present.
If,
yes.
Like I said, if you're trying to gauge how it's going and you think it's going poorly, and the other attorney is asking you questions and you're getting frustrated, I've seen people just their body language, they cross their arms, they slump down, and they'll almost just start agreeing. Okay, yeah, sure. Whatever you say, Craig.
And that's the worst
Whatever
thing,
you say.
worst thing you can do.
You're putting on the record
That you agree.
That you agree. And when somebody's reading it for appellate purposes later, they can't see that you're being sarcastic necessarily.
Yeah, Matt, talk about that a little bit. We are making a record. What does that mean? Explain to our listener what that means, that you're making a record when you're in a proceeding in open court.
Right. Well, anytime you're having certainly a trial, but most hearings as well are going to be on the record, meaning that there is a court reporter that is there in the courtroom that is typing out everything that's being said.
Yeah, they have a little machine, and they're actually not typing the words, but they have a special language where they're doing a shorthand where they are everything that is uttered out loud in a courtroom is supposed to be recorded, and that's what that person in front of the little machine is doing.
Right. So obviously, it becomes very important that you answer questions verbally. Okay. If I ask you a yes or a no question, it's important that you answer
Out loud.
not just shake your head.
And avoid slang. Certainly don't curse.
Even when you're saying, when you're giving an audible response, you want to be mindful of the words that you use, because things like and
They
look
sound
very
alike.
they sound alike, and they look very similar
when they're written.
So you want to be careful about the way that you answer questions, answer them as articulately as you can and as truthfully as you can. Okay,
Yeah.
Judges do not expect you to be perfect. Okay, they're not perfect. They don't have a perfect marriage. All day long, their job is listening to stories of people whose marriages are falling apart and who are, rife with imperfection.
Yeah, and vulnerability and just owning stupid stuff
Right.
is endearing. I mean, because like Matt said, there is no perfect person. And taking ownership of something that you did that was dumb is a good idea. And so the idea, Matt, then of making a record is basically that, again, you want to be able to communicate clearly, because if the judge gets it wrong, I mean, this is America, and you get another bite at the apple. And so there is a system in place to where if after hearing all of the evidence and information, everything that's in the courtroom, all of the documents they're being saved and recorded, and that becomes the record of that proceeding. And in the event you're unhappy about something the judge did, if you're in a final trial, now this is not true for a temporary hearing, and we could talk more about that, but at a final trial, it's going to be subject to appellate review. So in Mississippi, we have the Mississippi Supreme Court and the Mississippi Court of Appeals, and they are a panel of judges that review what happened at the trial court level, which is where divorces happen, the testimony that was spoken, the documents that were put into evidence, and they, if one of the parties believes that something the judge did was wrong or wasn't consistent with the facts or not consistent with the law, they have the opportunity to appeal the trial court decision to an appellate court. And we could do a whole nother podcast on that. But the bottom line is the reason a record is being maintained is because there is the option of having other judges review the outcome of your situation.
Right. Okay, so briefly, let's talk about when you're not on the witness stand. Same rules apply. The court is still observing you, okay? Sometimes actively, and sometimes it's maybe impossible to ignore you. I know I've had circumstances like that. I wish that it hadn't happened, okay? But you don't want to be sitting there at the table while another witness is testifying, and you are, being very dramatic or very acting your feelings, out loud.
Right. Or saying anything.
Right. Huffing and puffing, throwing pins.
Vigorously scribbling notes and just calling attention to yourself, even if the thing that the person from the witness stand is saying is the biggest lie you have ever heard. There's a certain level of composure, body language, poker face, that you just got to keep it together. If they're alleging that you are... you create all this chaos and you're acting like it from a witness stand without saying a word, the judge is going to believe them.
Right, exactly. And the flip side of that is, if your spouse's version or story is that you're not somebody who can maintain your composure, or the slightest little thing and your head spins around, and you just lose control. If what the judge is seeing in that courtroom, whether it be through your testimony or how you're behaving at the table, if that's inconsistent with that story, it's going to affect the credibility of your spouse's story.
That's right.
Well, I mean, he or she doesn't seem like they, just fly into a rage at any given moment or at the slightest,
right, because they are observing
misstep.
Things that are happening that aren't necessarily happening on the witness stand.
Right.
And you've got to be mindful of that.
Absolutely.
And I want to touch on this. We're almost out of time for today's show, but I do want to touch on this. And Matt mentioned it earlier. When your lawyer, let's say Craig Roberts, when I'm on my feet in the courtroom, I am trying to ask questions. I'm trying to anticipate objections. I'm trying to figure out if we have enough time. I'm trying to think about whether or not the judge is dialed in to what it is that we're communicating. So when I'm on my feet in the courtroom, I'm not doing one thing, which is asking questions. I'm trying to do about 5 or 6 different things. And so if you're passing me notes or calling attention to yourself, that creates a problem. And so what I tell my clients is just quietly with a lot of composure. Just keep up with not necessarily what is being said, but what needs to be asked based on what is being said. And so you can keep up with actually what is being said, taking notes like you would be if you were in a high school class or a college class. But you also want to be documenting questions that you want your attorney to ask, because if I'm asking questions, I'm not going to finish examining a witness until I come back to you and I say, okay, listen, anything else I need to ask them about? Is there, I thought about this, but I decided to skip over that because I didn't think the judge was going to like that particular part. Anything else that we need to talk about? Right. And so it's important to let your lawyer, you hired them, you're paying them a lot of money, let them do their job.
Right. If for some reason, if you show me something and choose not to actually bring that up to the court, I promise I'm going to explain it to you when we leave the courtroom. Right. Under that circumstance, there is a reason why I'm thinking that we either need to or don't need to get into something, okay? Yeah. All right. All the witnesses have gone. Both sides have rested. One mistake that I see people make all the time, and I admit sometimes I forget to even talk about it, is if you're going to have a divorce trial, this is an event that has been a long time in the making. Not just going back through your marriage, but a long time in the making through the divorce action itself.
Yeah.
And one of the ways that people commonly cope with this type of stressful situation is they've got this date in their mind and this enormous event. And so you naturally set it as it's over when the trial finishes.
I wish that were true.
Unfortunately, under most circumstances, if you had to actually have a 2, 3, sometimes more day trial, you're probably not going to get a ruling that day.
Occasionally you will.
Occasionally.
But
and
usually you don't.
That's sometimes dependent on who the judge is. So courts can do one of two things. They can rule from the bench, and that's maybe what you're sort of imagining would happen, which is the judge, everybody rests, and then the judge says, okay,
here's what I'm going to do.
This is what I've decided. And then you found out right then.
And sometimes they can do that.
Sometimes they can.
If it's very narrow, if it's one, we're looking for one amount of money, or we're making sometimes even a custody decision. If the only thing in dispute is does mama get custody or does daddy get custody, then they're going to go through the Albright factors and they might be able to rule right then. But more times than not, Matt, they don't.
Right. If the court's having to decide on who's entitled to the divorce, who's going to have custody, how much support the other parent's going to pay, what the visitation schedule is going to be like, how your assets and liabilities are going to be divided, all of those things, and they're having to weigh multiple different witnesses' testimonies. They're going to have to take some time to think about it, and that's called taking it under advisement.
Yeah.
So you're not, in 9 times out of 10, if you've had a multi-day divorce trial, you're not going to find out that day.
Right.
Now,
and they could make us do something called writing a findings of fact and conclusions of law. And that's essentially, I don't know how else to say it. They're asking the lawyers to pretend you're the judge and write a paper that they could adopt as their decision.
Right.
And that's a pretty common thing.
What do you think happened in the trial?
Yeah.
What
were the facts that were developed? What was proven? And what should the result of the dispute be?
And again, depending on who your judge is and what their docket's like and how much they have going on, if they take a case under advisement, you might have a written opinion in a couple weeks. In some instances, it might be a year.
And we've waited, unfortunately, in a recent case, we waited 2 whole years for there to be a decision. And there's rules about when courts can, when they're supposed to have decisions made. And, your lawyer is going to have to advise you with regard to if there's a judge who's taken a case under advisement and they've had it under advisement for 3 months, 4 months, 6 months, then, the lawyer will help advise you on whether or not it's a good idea to press the judge a little bit for a decision. Right. And again, every situation is different. Every case is different. The more complex the case is, the more likely it is that the judge is going to take time and ask for more feedback from the attorneys through some written materials to actually make the decision.
Right. So, that sometimes I guess we can include this inside of a discussion about divorce trials. Once you have received your written opinion, there may be some things that have to be clarified or things that have to be addressed. And so you might have some, what we call post-trial motions.
Right, where you're trying to figure out, okay, well, the judge said this in their opinion, but it is a little ambiguous and we didn't quite understand what it was. And so, honestly, you think that the trial is the end, but sometimes it is just the beginning of a new phase of the dispute, and it just depends on the people. Matt, gosh, there's just so much that we could talk about. I think we've come to the end of our time today. I do want to remind our listeners that, guys, divorce is terrible. And Matt, wouldn't you agree that the only thing worse than a divorce is one where there's a trial? And the only thing worse than that is when there's a trial, and then after the trial, there's ongoing dispute and a possible appeal. The only thing worse than a divorce is one with a trial. The only thing worse than one with a trial is one that'll never end.
Right.
And we really do want our clients to be able to move on, to live healthy, happy, fulfilling lives. And sometimes the divorce trial is just a roadblock that you have to overcome. And gosh, it's just, if you can avoid a divorce trial, you certainly want to.
Yeah, you should. For many of the reasons that we covered today, not just the hurt and damage that the proceedings of the testimony cause, but the time, effort, expense, usually it's left open-ended, at least for a period of time.
Right.
If you can reach a settlement, there are intrinsic, value. There's intrinsic value to it, like closure, like knowing that it's over, being able to have control over that and say, all right, I'm putting a period at the end of this sentence and I'm moving on. Again, sometimes it's unavoidable.
Right.
And if you have to do that, make sure that you've got somebody on your side that knows what they're doing. Listen to them.
Yeah.
Because just if they know what they're doing and you don't listen to them, you're basically wasting your money.
Wasting your money.
I've had plenty of people say, oh, well, y'all are supposed to be the best or this or that. I hired you, so that means I win. No,
you got to do what
you hired me
say you do,
so that I can help you figure out the right way to present this, and let's tell your story in the correct way. You've got to do your part. There is no bigger piece to a divorce trial than you. I mean, okay, you're the one you're the star.
You are the star of the trial, that's for sure. But gosh, it's if you can avoid it, you really want to try, because you're taking all the power away from yourself and your spouse and giving it to a stranger, and it does.